Morning, members. Morning, colleagues from the department. Mr. Roberts, can you test the system, please? Can you start sharing?
Thank you, Saya. Can you see it?
Not yet. Wait, not yet.
Let's try again.
During the process of the public hearings. Members, you might be aware that I have sent you a letter from Advocate Prince requesting an extension for them to be consulting with the department on exemptions for cultural and religious purposes. I would like to make the following suggestions for consideration by the committee: that we proceed today with the responses from the department, and we will only skip the part that deals with the exemptions for religious and cultural purposes, and we allow the department and the Rastafarian community up to the 8th of March to ensure that they make their submissions, bearing in mind that once this bill is passed by the National Assembly, it will go to the NCOP, and the whole process will start again, the process of public hearings, submissions, and the people who have made presentation to the NA, they are as well entitled to make the presentations to the processes in the NCOP. Your views, members? Honorable Breitenbach.
Good morning, Chair. Thank you. I'm sorry, I was struggling to get admitted. Could you just briefly tell me what it is that you've just said? I missed it.
Okay, I was saying that we received a letter which I sent to all members from Advocate Prince
Oh, yes, of course. Okay, I get it. Yeah.
Yes, so I was generally asking that we proceed today with the responses from the department, and then we only skip that that part that deals with submission, in fact, that deals with exemptions for religious and cultural purposes. We will deal with it after the 8th of March. We allow them time to make their submissions to the department, because even when you look at the bill, the department has left that space open, awaiting a response from the Rastafarian community. So I was proposing that we proceed with all other clauses, and then we leave that clause that deals with the exceptions, and then the exemptions, then we will deal with those after the 8th of March.
Thank you, Mr. Chair. I agree with you 100%. Thank you. When you finish with Mr. Swart now, just have a word, please. Thank you.
Okay, thank you very much, Honorable Swart.
No, Chair, I'm totally in support of your view. I think it's an important consultation that needs to take place as well, but there will be that opportunity to consult. I just also, so I support what you're saying. I also presume that Mr. Robertson will also give us feedback during his presentation on the other issues which we asked consultation about with professors and other departments about the possible negative impact on the use of cannabis on adolescents. I presume we'll get feedback during the course of today and tomorrow. Thank you very much, Chair.
Thank you very much, Honorable Swart. I think there's a problem with your audio. We are struggling to hear you. If you can just attend to it.
Thank you, Chair. Well, thank you.
Thank you very much. Any other view on this issue before we go to Honorable Breitenbach? So we are all in agreement, members. Thank you very much. Honorable Breitenbach.
Thank you, Mr. Chair. I did mention to you previously, and I did inform Vonani, the DI has a new member on the committee. It's Mr. Engelbrecht. He's been appointed as the Shadow Minister for Correctional Services. So if possible, I'd like him to switch on his camera so I can introduce him, that you can all see what he looks like. Janu, could you please switch on your camera and say good morning to everybody? It's Mr. Janu Engelbrecht. He's from Gauteng province.
Oh,
thank you very much. Thank you, Mr. Chair. I look very much forward to working with everyone here, and I think that it's an interesting yet busy portfolio, as I can see. But yes, I will give my all to give a good and well thought through contribution wherever I can. Thank you very much. I look forward to it.
no, thank you very much, Honorable Engelbrecht, and welcome to the Portfolio Committee of Justice and Correctional Services. We are really pleased that you have joined us. And we are also looking forward to be working with you and with all other members of the committee. Thank you very much, and thank you very much, Honorable Breitenbach, for bringing that to our attention so that we can welcome the new member to our committee.
Thanks, Mr. Chair. Thank you.
Thank you very much. Thank you, Honorable Engelbrecht. Mr. Robertson, can you proceed? And the other issue members, can I ask that we adjourn at 12:20 for today? There is a meeting that has been called by the House chairpersons that will be dealing with the program and the bills that are before our committees. Thank you.
Thank you, Mr. Chairperson.
Is there an objection to that?
Most certainly.
Okay. Thank you very much. We can proceed, Mr. Robertson.
Thank you, Mr. Chairperson. Can you
And
see the
and Happy New
document?
Year. And Happy New Year.
Thanks. Can the members see the document?
No.
Can you share again, Mr. Roberts? I took it off for the introductory part of the meeting. Can you share again? Thanks.
Try again. The document
Yes.
visible?
Yes, we can see it now.
Thank you, Mr. Chairperson. The document before the committee is basically a reworked draft of the bill, taking into account the comments and responses, and also consultations that was done with certain persons. I'll discuss part of, or rather discuss the comments and responses in respect of which we had to consult with other persons in conjunction with the clauses of the bill. So I'm going to start off now. The first proposal relates to the definitions in the bill, and that is of adult person. In the comment and responses, there was indication by Professors Perry and Mayers regarding the fact that cannabis have adverse impact on brain development of young adults and obviously also children. I did indicate that other jurisdictions have got different age restrictions on the sharing, or rather the commercialization of cannabis in the respective jurisdictions. I did refer the committee, amongst others, to applicable South African legislation, the Liquor Act and the Tobacco Act. Professor Perry, maybe in this regard.
Mr. Roberts, I think
Yes.
there's also a problem with your audio. We can't hear you properly.
Mr. Chairperson, it's probably our internet at work. I'm going over to a 3G card. Let's see how we can proceed on that basis.
So can you give you 2 minutes to make the change over?
Please,
Okay.
thanks. Mr. Chairperson, let's try again. Can you hear me better now?
Much better.
Okay, let me start again. The first proposal, or rather the first provision of the bill that has been considered relates to the definition of adult person, which is currently stipulated or defined in the Act as a person who is 18 years or older. I did, or rather in the comments that were received, mainly from Professor Mayers, there has been an indication to the effect that cannabis affects brain development. Brain development continues until a person is 25 years of age. In the responses to the comments, the department did refer to other jurisdictions to indicate what is the age limit from which a person may use cannabis. Most of the foreign jurisdictions is either 18 years of age or 21 years of age. I did refer to applicable or comparable South African legislation, namely the Liquor Act and the Tobacco Controls Act, which currently still regard a person as an adult if he's 18 years or older. During consultations with Professor Perry, he reiterated what he said in his submissions, namely that cannabis adversely affects young adults up to 25 years of age. And I did request him to make a proposal regarding probable restriction that can be placed on persons that is allowed to use cannabis in terms of the bill. He indicated firstly that most states in the United States set a 20 years age limit. He also further indicated that if that is not acceptable, it may be restricted to 19 years of age. And he indicated that most people who have finished their school years by that age. So a proposal is made as an option in the bill that we can consider to upgrade the age limit to 21 years of age, or as an alternative, we can probably also consider 19 years of age. I must indicate that similar amendments were proposed to the Liquor Act, namely to raise the age of persons that is allowed to use liquor to 21 years of age. And that legislation has never been finalized. So two options, or rather three options, is before the committee. First, that we define adult person, as is the position currently in most legislation, as a person who is 18 years or older. Second option is to define it as a person 21 years or older. Third option, we may define it as an adult person who is 19 years or older. Going to continue relating to the definition of cannabis. It's the next definition that we considered.
Sorry, Mr. Roberts, just hold it a bit. Members, I would like to be guided. Would you want to discuss as we move along, or you will just be listening to the responses? Then when we come in March, then we do the deliberations, or you would rather have some discussions taking place so that we are able to guide the drafters?
Okay, Swart,
Honorable Swart.
I hope you could hear me clearer now. I think we need to have discussions as we're going along, because there are a number of very important issues, and rather than have a total presentation, one might use the points that we are making. I see there are a number of hands up already on this particular issue, so maybe we can hear what other members say, but maybe we should discuss some of these very important issues as we are presented them. Thank you.
Okay. Honorable Swart, your audio is still a bit problematic. I know you have strong views on this bill, so it will be important that we hear you properly. If you can try and attend to your audio. Is there any view that is contrary to what Honorable Swart has raised? I see none. So can we proceed along those lines? So can we have a discussion on the adult person, the age, whether it's 18, 19, or 21?
Okay, may I continue on that issue?
Yes, please.
Please just tell me if you can't hear me, then I will come back at a later stage and try an alternate device. This does raise a critical issue that we have from the ACDP side, raised our concerns about the whole impact on the bill and our broader opposition because of the impact on children, on adolescents, on society. Now, whilst I would welcome an increase up to cannabis, I don't know if this covers the challenges that one faces. And I think this is where the further consultations, deliberations must come in, because the approach of the department is that they do not deal with harm necessarily caused. That's dealt by other departments and other pieces of legislation, such as the Prevention of and Treatment Act for Substance Abuse Act. That's other departments, but we as legislators have to take that into consideration when we pass in this bill. What is the impact on broader society? So I just want to flag that issue, that is one of the main reasons for our strong views on this bill.
Thank you. Thank you, Honorable Swart.
Could you hear me clearly, Chair?
Yes, we did. I did, but with a lot of strain.
Okay.
Yes. So if I understand you correctly, Honorable Swart, you are saying that you have those concerns, but for now, with respect to this discussion on the elder person, you would settle for 21 years.
Yes, with those other concerns. Thank you.
Yes, and then the other concerns will be discussed as we deliberate on the bill. I think as we go down, I think there are other areas that we'll try and raise those issues, of which I think we would need to come back to some of the concerns that you have raised so that we check if there are any responses. Members, there is a suggestion of 21.
Chair.
Oh, Honorable Yako, it's a pleasure to see you back again.
I think with regards to this discussion, 18 seems to be what in South Africa is an adult age. So I'm not sure if we should oscillate between 21 and 18, but to me, 18 seems to be a standard age, and it would be strange for me to deviate from that.
Okay. Thank you very much, Honorable Yako. Other members?
Okay.
Honorable Horn?
I don't know whether the raise hand function is not showing at your side.
Yeah, but I see your hand now.
Okay. Yeah. Thank you, Chair. Yeah, look, firstly, I think in terms of the way this is phrased, I think we must be careful in the sense that the Honorable Yako, let me say this. I think the Honorable Yako is quite correct in that I think it's now settled in South Africa that you are deemed to be an adult at the age of 18. So therefore, if we are then to consider a proposal to use an increased age of 21 years, I don't think it should be done in a way that where we define an adult person to be a person of 21 years. I think then the whole way in which it is phrased will have to be redrafted. So that's the first issue. The second issue on a matter of ultimately deciding what is the way forward, I want to raise the issue of whether we should be guided in this sense by a single input. So it is, in saying that, I'm not downplaying the value of the input of the professor who said, but the one thing this parliament should consider is the fact that brain function and capability is developed until the age of 25, and therefore one should consider whether lawful usage of cannabis should be allowed before that. But for us to place ultimately a reliance on a single input in this regard, I would find problematic. So I don't know whether the department in preparing responses were able to look into the scientific views of others in order to guide us, and if not, I don't know what the way forward is, whether we should ultimately then from our side source other views. But if the whole issue of developmental capacity and the impact of cannabis use is going to be the yardstick by which we approach this, I think we should trust science as it stands rather than one opinion. Thanks.
Thank you very much, Honorable Swart. Are there any other views before I allow Mr. Robertson to respond?
Yes, please, Chair, my hand is up.
Oh, okay, Honorable Regenbach.
Thank you, Mr. Chair. Yes, I'm partially covered by Honourable Horn. I agree fully that we won't be able to define an adult as somebody older than 18 because an adult is already defined as 18 and older. And I do really want to align myself with the view that I think we need more in-depth research about the effects and brain development before we just take a sort of a decision almost in limbo about it. So I'm certainly not disparaging, excuse me, disparaging the information that we have, nor the source thereof. But I do think that we need to cover that a whole lot more effectively before we take a decision like that. Thank you.
Thank you very much. Members, you should bear with me. It's difficult for me to see your hands because of the slides. Is there any member who has raised his or her hand?
Yes, Chair.
Yes, Chair.
Honorable Janji, is it Honorable Janji?
No, Chair. This is Tebo Khotlopane from the Cannabis Trade Association, Chair.
No, the time for public hearings is now over. People who are allowed to speak during this process is members of parliament.
I wasn't aware of that, Chair, but thank you for the clarification.
No, thank you very much, Mr. Tlopane.
Thank you, Chair.
Thank you very much. But you will still have the opportunity to raise your issues when the bill goes to the NCOP. Public hearings are going to be invited again. Any other? Thank you. Any other views, members? Okay, Mr. Robertson.
Chair.
Oh, Honorable Janji.
No, Chair. I support the colleagues so that we're on the side of caution on this matter, that more in-depth work be done, and because there's got to be very good reasons why you would ignore 18 and go to 21 in the definition of this adulthood. So I think as a committee, we'll be better off to give ourselves time and get a proper definition of this, which is not one-dimensional in its nature. Thank you, Chair.
Thank you very much, Honorable Janji. Mr. Robertson, I think the direction from the members is quite clear. Any preliminary responses before you go back to work on this issue, take into consideration what has been raised by members?
Thank you, Mr. Chairperson. During our discussions with Professor Perry, he did indicate that he will make new research available that was done in America regarding the impact of cannabis on the brain development on young persons. So I'm awaiting that response. I can probably not take it further at this stage. The second definition to be considered relates to the definition of cannabis.
Mr. Roberts, personally, I would have a bit of a problem that you are going to be relying still on one person to give you a research that, I mean, quite clearly, she will give you a research that favors her worldview. I do think that you should consider a wide range of research on this issue, not the person who has advanced a particular view, and then you just rely on that one to say she must further give you further evidence or further research. Mr. Robertson?
Mr. Chairperson, sorry, it's noted. I do think research is quite important since America is one of it's research that was conducted in America. So it is research that is independent from Professor Perry. I also do think that it's probably the only research that was conducted. There are views available on the internet regarding the impact of cannabis on young persons, but it's not a scientific and research document. So that is probably the only document. My view, on the other hand, is as a provisional view, is to the effect that an adult in South Africa is 18 years of age, and we shouldn't likely deviate from the age of adulthood that is set by other legislation. I will consider other inputs as well as the research that Professor Perry will give to me, and I will go broader if I can and make any recommendation in this regard.
All right.
Going further then, the next definition to be considered is that of cannabis. Two aspects that is addressed in the newly drafted definition. The first is the definition that cannabis consists out of flowering or fruiting tops and leaves of a cannabis plant. The proposed option here omit leaves from paragraph A of that definition. And that is mainly due to the fact that leaves only contain trace elements of THC. A drug effect on a person. So I will propose that we omit leaves from the definition of cannabis in paragraph A. I can also refer the committee members, amongst others, to the commentary on the 1961 Single Convention on Narcotic Drugs, where it actually indicates that leaves should not form part of a definition of cannabis in that convention. And that's mainly also on a basis that it contains minimal amounts of THC. The second amendment to the definition of cannabis that is proposed relate to paragraph B, and that is in relation to a substance. Comments were previously raised that the department should consider a minimum amount what the substance should contain. And that's obviously it's quite relevant to, amongst others, the offences in section 5 that criminalize the consumption of cannabis in a private place, and also in relation to the offences that is created in clause 6 that deals with the administration of cannabis to a minor, and to determine an appropriate amount of THC is quite problematic in this instance. If one look at the regulations made in terms of the Medicines Act, one will see that the 2020 regulations amend Schedule 6 of the Medicines Act to more or less indicate that it excludes, THC excludes cannabis containing 0.0 0.001% THC or less if it's in terms of a product that is used by an adult person. In respect of raw plant material and processed products that's manufactured for non-adult use, a limit of 0.2% THC is specified in the product. My submission is that 0.1% or rather 0.001% restriction in that regulation is unworkable for purposes of this act. That is more or less was indicators that it only contained trace amounts of THC. It's further submitted that 0.2% quantity of THC can more readily be used in terms of the definition in terms of this bill to quantify what is a THC product. One must also take into account that cannabis is regulated here mainly for private purposes. It's probably better to specify a quantity of, but one must take into account that if hemp regulations or legislation is to be enacted, this provision may impact on that. Specify a quantity of up to 0.5% in this regard. So that is the amendments to the definition of cannabis proposed to the committee as a second option. Thank you.
Thank you very much. Any views, members?
Yes, Swatcher.
Honorable Swart.
I didn't quite understand Mr. Robertson where he referred to the 0.2% as being unworkable. I'd like clarity because that obviously relates to the challenge, as you point out in your note about hemp and South African conditions for hemp, where the 0.2% might be too low considering South African conditions as opposed to other conditions. Can I just have greater clarity? Are you suggesting 0.2% or are you saying it is unworkable, as many other members in the industry in the hemp industry have said 0.2% is unworkable?
Thank you, Honorable Swart. Any other view?
Chair, it's Werner Hond speaking.
Honorable Hond.
Yeah, Chair, I would just like Mr. Roberts to comment, and I know it is something that we as a committee has been acutely aware of, and that is the fact that this bill is on the one hand the product of a constitutional court judgment and therefore has this narrow focus of regulating the private use of cannabis in South Africa. And then we, on the other hand, were acutely aware during the public participation process that parallel to that, there's this dire need for wholesale regulation of the cannabis industry. And now, luckily, we know from SONA that is a process that will be unfolding. So I would just like Mr. Roberts to also give some guidance and advice as to what extent does this definition speak strictly to us then in adopting this bill, hopefully one day, sticking to the brief received by the Constitutional Court, and to what extent does this also then go a bit further and talk about regulation issues in general? and whether the definition as it now stands is necessary in order to just satisfy the Constitutional Court judgment. Thanks.
Thank you, Honorable Horn. Any other member? Mr. Robertson?
Thank you, Mr. Chairperson. First, in relation to Mr. Swart, the questions that he raised, I give 0.001% restriction is completely unworkable. That's trace elements. Regarding the 0.2% quantity limitation, one must remember that amongst others, in the bill, there is offences that indicate a person may not consume cannabis in a public place. One must also take into account that most cannabis oils that is currently sold prohibition in them.
Mr. Robertson? Mr. Robertson? Yes, can you change your device? We are struggling to hear you.
Give me a minute.
Okay.
Mr. Chairperson, is it better?
Yes, better.
Start again. I did indicate the 0.001% THC limitation is unworkable. That is mainly anything that contains a trace amount of THC. The 0.10 quantity limitation it will amount to a prohibition in terms of the Medicines Act, since it cannot be used for by a person. It cannot be consumed by them. Further, the 0.2% THC also emanates from an amendment in the to the 1961 Convention. Substance containing 0.2% THC should be excluded from international control. The unworkability of the 0.2% THC in the context of the bill is that the aims of the bill is mainly to regulate personal use of a substance containing THC. And one can actually ask how much must be consumed by a person to get on a cannabis high. And I did indicate that one can probably consider a 0.5% THC limitation in this regard, since it more or less tried to address a substance that has got a drug effect. So unworkability in this context mainly relates to the aims, what the definition seeks to achieve in the context of the bill. I must admit, yes, insofar as it relates to the offences relating to children, 0.2% THC limitation should be considered, but for purposes of clause 5, it should probably be increased to a higher limitation in respect of that offence. Regarding the question of Mr. Horn, I couldn't hear everything that he asked, so I just want to ask him to repeat it, please. Mr. Horn?
I think after Mr. Horn, Honorable Jailer would like to also make a contribution.
Yeah. Now, I was asking Mr. Roberts to what extent this definition is necessitated by the purpose of this bill, and that's to allow for the lawful private use of cannabis. And to what extent does it possibly go a bit further into the terrain of regulating the cannabis industry, something which we were quite aware during the public participation, which is a necessity, and which from SONA we know will be undertaken now, if not by this department, by other departments. So if you could just advise that this definition is strictly necessary for the purposes of this bill and do not go a bit further. Thank you.
Thank you very much, Honorable Jale.
I think earlier I wanted to make a contribution when I was covered that more research would be done and then we'll get more opinions on this matter. For now, I'm still covered, Chair. It was earlier when I wanted to make a contribution. Thank you.
My apologies, Honorable Jale. I did not see your hand, and my apologies. Mr. Robertson.
Thank you, Mr. Chairperson. Regarding the open 2%, the bill currently specifies in relation to hemp that it must be a plant containing a percentage of THC that is specified by other legislation that regulates hemp. If one looks at, amongst others, New Zealand legislation, Australia legislation in respect of hemp, one will see that a higher amount of THC has been determined in respect of hemp. I think in some Australian jurisdictions, it's up to 1% THC. Regarding the possible impact it may have on other legislation that regulates commercialization, is mainly to the effect that it provides for a limit on any cannabis product containing THC. It may not be very workable in terms of commercialization, where one actually do sell a product that must contain THC to get a drug high. So it's just that it may be considered as a limitation bill on future developments on cannabis. It is correct that the bill is an interim measure. It can be amended at a later stage by other legislation. And even for purposes of the bill, we try to regulate harmful effects of THC. And to that extent, 0.2% limitation, one may well ask the question, what effect can such a substance induce on a person? So that's mainly my response. Thanks.
Thank you. Are you clarified, Honorable Horn?
No, whilst I must admit I'm in no way an expert, I do think I followed. Thank you, Chair.
Okay, thank you very much. We are not going to be making definite positions for now. I think members are going to reflect on what has been said. And then when we come back on the 8th or 9th, we will start to deliberate. I think members would have applied themselves. Can we proceed to the next one?
Thank you, Mr. Chairperson. The next definition is that of cannabis plant. There's no option proposed. I just want to point out that the flowers and fruiting tops that actually do contain THC. It's mainly produced by a female plant. It's, however, the definition of cannabis plant cannot be drafted in a manner that indicate that it only relates to a female cannabis plants, due to the fact that there are instances where there is plants that contain both male and female flowers. So it's mainly just an explanation to indicate why cannabis plant has not been defined in relation to a female cannabis plant. Then the next definition is that of child. My submission is that amendment to this definition can be considered at a later stage if we clarify the allowable age limit under which a person may consume and use cannabis. Regarding the definition of commercial quantity, an option is proposed that mainly clarifies the definition further in relation to the trafficable quantity definition. And it is the amendments that is proposed to this definition indicates that it is the prescribed quantity in column 3 and any quantity in the dried cannabis is the following definition to which additional or option is proposed, and the new definition is to remove leaves from dried cannabis, and that is as a result of what was discussed previously, namely that leaves contain minute amounts of THC only. There's also a proposal that the definition of fresh cannabis should be amended, then to exclude leaves from that definition. Regarding the definition of immature cannabis plant, it is currently defined that it is a plant that is taller than 15 centimeters or wider than 15 centimeters. And it was indicated previously by the committee that this is an unworkable indicator. And I did indicate previously that the height and width indicator was there to distinguish it from an immature cannabis plant. I did revise the definition, and it's my submission that this indicator of 15 centimeters may be removed from the definition of mature cannabis plant. I will further deal with this definition where I deal with the definition of a seedling.
Members, any comment on this one? You can proceed.
Thank you, Mr. Chairperson. Although the current definition of seedling still contains the 15 centimeter indicator to distinguish it from an immature cannabis plant, it's my submission that it can be increased to at least 30 centimeters. This is necessary due to the fact that the person that possesses seedlings does not possess an immature cannabis plant. And there's different to seedlings and immature cannabis plants. Although the current definition do specify 15 centimeters, be amended, or rather it be extended to at least 30 centimeters. In relation to an immature cannabis plant, there is a need for this differentiation. The remainder of the definition stays the same, especially that it must be a non-flowering cannabis plant to qualify a seedling from an immature cannabis plant. And in most instances, a 30 centimeter cannabis plant will not be flowering. And even if a person do cultivate it, mainly in enclosure, where they can grow or produce flowers at the 30 centimeter height, it's adequately covered by the fact that it must be a non-flowering cannabis plant, meaning not containing cannabis that can induce a drug effect. Thank you.
I don't see any hands.
I'll continue.
So the decision that you require there is between 15 and 30 centimeters.
That's correct, and I will propose that it rather be increased to 30 centimeters. Regarding the width, I must further explain that it's possible to cultivate a cannabis plant that grows similar to, amongst others, a pumpkin or other ranking plant. The next definition to be considered is the option to smoke. In the comment and responses, there was an indication that the definition of smoke does not cover vaping, and the definition is mainly amended to include, or rather to provide for vaping, which is covered by paragraph B, which specify it as to inhale or exhale vapor or aerosol of a cannabis produced by a vaping device, or holding or otherwise having control of a vaping device producing vapor or aerosol. Thank you. Can I continue?
You proceed.
Next definition is the option to trafficable quantity. The amendments is mainly to clarify that definition further in relation to a commercial quantity. Definitions to be inserted. We did not take this into account, and it has not been inserted in the bill. Regarding subclause 2, subclause 2 provides for authorization under which person cannabis plants or cannabis product or otherwise cultivate cannabis plants. There's mainly a discussion regarding commercialization that is given here. And the committee is probably aware that various commentators did propose commercialization. I can also even refer to Professors Perry and Meyer that indicate that the current services available to persons that is a cannabis addict is actually dwindling. There's not enough resources available. There's a need for public education regarding the harms of cannabis. And there's a need for improved population monitoring to deal with the associated harms of cannabis. I can also refer to the comment of the South African Medical Association to the effect that they actually caution South Africa regarding ongoing decriminalization, but they also urges then that there should be available resources to cater for treatment and prevention and harm reduction in respect of cannabis, in this context mainly, rather drugs, in this context mainly cannabis. I can also refer the committee to the comments of various commentators who indicated that the practical implementation of the bill may have certain shortcomings, and it relates mainly to the policing thereof. The committee was briefed about cannabis master plan that supports commercialization of both cannabis and hemp. And there has been documents where at the previous stage was made available to the committee that discusses the various models of cannabis regulation. And I did indicate that Canada, Uruguay, and amongst others, various states in the United States implemented a commercial model for cannabis regulation. And the reasons for that model is mainly that the current regime to control drugs is not very effective. And other assumptions on which such a model for cannabis regulation were implemented is, amongst others, that many persons who consume cannabis do not self-cultivate, but buy it on the black market, and that in turn promote to illegal cultivation, illegal black markets, organized crime, distribution of cannabis to children, since it's mainly unregulated. The distributors of cannabis use children to deal in cannabis. In many instances, cannabis is distributed that is laced with harmful substances. And there's various other types of criminal conduct that goes with dealing in drugs on the black market. Further assumption that they use to substantiate their decision, amongst others, is that prohibition mainly enrich criminal organizations, and it places substantial financial burden on the state to deal with the harmful effects of cannabis. And there's no pro quid pro to deal with that. And they also did indicate that a commercial model has the potential to ensure that many illegal activities are curbed. Also makes it less profitable for criminals to deal with cannabis. It ensures a product that is safe. It ensures that the proceeds that are obtained through illegal selling of cannabis are diverted from criminals, mainly to government, to deal with the harmful effects of cannabis. They did indicate that the commercial model ensures that statistics of the extent of cannabis consumption are available to government, who can then evaluate that, implement appropriate responses to the harms of cannabis. And they also indicate that commercial model make it easier for government to implement certain measures to deal with harm reduction. A further assumption is that it actually, commercialization will provide for job creation, and it will stimulate the economy. Further assumption was that the criminal law has no right to interfere with a person's behavior if it does not cause harm to another. They did indicate that the current regulatory measure to deal with cannabis regulation, where it relates to prohibition, actually just ensures that more funds are obtained by criminal organizations. And obviously to address drugs under a prohibition system requires substantial financial resources, and that can also probably be set in terms of the bill. If the bill is to be enforced in police, it will require substantial resources. They did indicate that cannabis is a soft drug and should not be subject to the same harsh control measures currently imposed by the drug conventions. And it's my submission that if a commercial model for cannabis regulation in South Africa is implemented, it can be justified on similar grounds as that. I'm not going to go or specify each and every contention in that regard, but I must indicate that one of the big issues here is our obligations in terms of the international drug control regime. Currently, previously in the committee, I did indicate that the current bill is not an appropriate instrument to deal with cannabis legalization in the context of a commercial model. But there is a possibility that the bill can be amended to an extent that ensures that regulations may be made to regulate cannabis commercialization in terms of the bill through subordinate legislation. I must, however, indicate that we do require the buy-in of other appropriate departments, amongst others, the Department of Trade and Industry, Department of Social Development, Department of Health, and Department of Agriculture, if this is considered as an option to implement cannabis commercialization. Thank you.
Thank you, Mr. Robertson. Any comments, members? Honorable Swart, are you covered?
Yeah.
Honorable Juan?
Well, the Honorable Swart is strangely silent. If I may, I think that the point that this bill is not suitable to even on a temporary or interim basis regulate the commercialization of cannabis or the industry. I think that point is well made, and that ultimately was the sense I formed while listening to the different views of those who presented during the public participation phase, and while not discounting the dire need for regulation, the reality is that this bill, in my view, is not the vehicle. We now have the announcement that it is on its way. So looking towards that very last paragraph in which Mr. Roberts suggests that maybe as a stopgap measure, regulations could be used to enable something. The difficulty I'm having with that is that the public participation just showed how complex this whole issue is, and that any attempt to, on an interim basis, allow for commercialization through regulations may ultimately be counterproductive. So whilst having a lot of sympathy for those who are looking towards Parliament to embark on this overdue process of regulation, ultimately, I must say that I think ours at this stage is to stick to the narrow purpose of the bill based on the Constitutional Court judgment. Thanks.
Thank you, Honorable Horn. Any other hands? Mr. Robertson? Mr. Robertson?
Thank you, Mr. Chairperson. The next paragraph relates to a call. Mr. Chairperson, can you hear me?
No, maybe you can change your budget again.
Is it better now? Hello?
It's
Thank you, Mr. Chairperson. I continue then, and that relates, next clause is quantities for personal use by adult. The only amendment that is proposed to the current provision relates to subclause 3. And the clause do not provide or give guidance whether, for a time period within which it may be exchanged. And previously I did indicate that the exchange under this subclause is per occasion, and the amendment mainly addressed this aspect by inserting the word, or rather words, per occasion in subclause 3. A more extensive amendment to clause 2 relates to self-medication and requirements in excess of prescribed quantities. This is where a person wishes to self-medicate and probably require a quantity of cannabis or cannabis plants that exceed the prescribed quantity. The new proposed subclause 4 provides for self-medication and is to the prescribed quantities. And it provides that adult person who has been issued with a certificate by an authorized person in which it is certified that he or she is a person who requires palliation, or is a person that suffers from a moderate or severe chronic debilitating physical or mental health condition, and who attempts to self-medicate, may for personal use cultivate, obviously again, prescribed quantities of cannabis plants, may possess a prescribed quantity in a public place and possess, and that quantity is in excess of the current prescribed quantities. It further provides that an adult person who is a person that requires palliation or suffers from an illness may also obtain quantities of cannabis without consideration that exceeds the prescribed quantities, and the criminalization in subsection 3 would also not apply to other adult person who furnish or give that they give that quantities that exceeds the prescribed quantities to such an adult person. Further amendment is mainly to the effect that an adult person in subsection, or rather paragraph A, may in private in a public place use cannabis. That's obviously seen as a measure to facilitate self-treatment. And the certificate that must be issued must be in a prescribed form and contain the prescribed information.
Mr. Roberts, we can't hear you.
Sorry, Mr. Chairperson, can you hear me?
Yes, we can.
D provides that the certificate is, okay. Paragraph D provides for a certificate with prescribed information that needs to be issued, and amendments to the regulation enabling provision provides for the making of such regulations in conjunction with the Cabinet Minister of Health. To clarify it further, there's definitions in the current provision who defines who is the authorized person, and that's a psychiatrist. Contains a new definition in private use to provide or facilitate self-medication of a person. And that definition indicates that in private use means to consume cannabis in a manner that conceals it from public view. And you can even smoke cannabis in a public place in contravention of section 5.1 and other prohibitions in section 5.2 to 5. But it must be in a place that is concealed from public view. And the prohibitions that is contained in clauses 5.2 to 5 is still applicable to it, which actually restrict it to certain places. You cannot smoke it in the near adult person or a child, or at such a place that may cause hindrance to other persons. There's a definition of person who requires palliation, and it's defined as a person when of an authorized person as an advanced request by the end of this definition of self-medication cannabis in order to palliate pain or suffering of a person that requires palliation, and in respect of an adult person who suffers from a chronic illness, to treat or mitigate the physical or mental conditions or the symptoms thereof. So that is the new option that is proposed. I must indicate there is consequential amendments that needs to be affected. That's mainly in Schedule 3 to prescribe quantities. For purposes of this clause, I did indicate the possible prescribed quantities that may be considered. I'm not going to go through it. There's also a need for amendments to clause 3, 4, and 5. And obviously the amendment to clause 9 to provide for regulations pertaining to the certificate. Thank you.
Thank you, Mr. Robertson. Any comments, members? None. Can we have a 10 minutes break, comfort break until 11 o'clock? And can you use that time, Mr. Robertson, to deal with your gadgets? Because sometimes we struggle to hear you.
Mr. Chairperson, I'll try to deal with it. Thank you.
Can you come back at 11? Thank you.
All right.
Welcome back. Let us proceed.
Thank you, Mr. Chairperson. Thank you, Mr. Chairperson. I hope it's better.
Yes, it's better now.
Thank you, Mr. Chairperson. Clause 3 of the bill mainly deals with cultivation offences. Amendments to this clause mainly emanates from comments that the penalties that may be imposed in terms of the bill in respect of certain contraventions of the Act is extremely harsh. A further amendment that is affected to this clause relates to the fact that no flowering cannabis plants may be shared between adult persons. The first amendment relates to subclause 1, and that is in relation to paragraph A, where the class of penalty that may be imposed is restricted to a class D penalty or offence. Paragraph B is further amended to provide that a contravention of a trafficable quantity of cannabis plants will only emanate to a class C offence. In respect of a commercial quantity of cannabis plants, the current offence classification, namely a class A offence, is being maintained. In the schedule to the bill, there is also certain amendments to accommodate this aspect, which I will discuss later on, I think, when we do deal with that. But in respect of a commercial quantity, the prescribed limit is still the equivalent of 10 flowering cannabis plants in respect of a person. I'm going to stop there. Thanks.
Thank you. Members, any comments or questions? Now, can you proceed?
Thank you, Mr. Chairperson. The second amendment relates to subclause 2, and the clause is amended to take out the provisions that requires that a person must take reasonable measures to ensure that cannabis plants is inaccessible to a child. That is in relation to comments that it's better to prescribe that by regulation. So the amendment to subclause 2 therefore requires that a person who cultivates cannabis plants must comply with the requirements and standards prescribed by regulation. Thank you.
Proceed.
Thank you, Mr. Chairperson. Subclause 4 is amended, and that deals with the criminalization where a person exchange without remuneration cannabis plants to another person. Paragraph A is amended to make the class D offence where a person exceeds the prescribed quantity. In respect of a trafficable quantity, it's now degraded to rather made a class C offence. And in respect of a commercial quantity of cannabis plants, the current classification as a class A offence is being maintained. There is also some amendments to the schedule which make the gap between a trafficable quantity and a commercial quantity higher. I'm going to proceed further. Option 5 deals with the possession in a private place, in a public place of certain cannabis plants. And the Class A offense, which deals with the possession in a public place of a cannabis plant that exceeds a prescribed quantity, is guilty